appreciate it. Thank you for the invite and allow me to talk with you today. As I mentioned, as people were trickling in earlier, this is designed really to kind of do a few things. One is to kind of give a refresher on 25 CFR 169 and the right-of-way regulations as they pertain to appraisal, and then also talk about some of the particulars of rights-of-way that often are overlooked or not thought about that can be negotiated as part of the 2015 regulation changes, and kind of what the impacts are from a valuation perspective. That's where I kind of come from. Not so much the legal perspective or the realty perspective or the landowner perspective, but from the valuation perspective, and I see kind of what things are not included or talked about that have an impact on value or can have an impact on value that need to be, kind of part of the negotiating process. So that's kind of where this will center. I put this in here not so that you have a picture of me, but so you say, who is that guy that talked to us about rights of way? So I've been with the federal government as an appraiser since 2000. I started at the Colorado State Office for BLM at that time, and I worked with the Forest Service for a while, came back to Interior, and as I in the introduction said, I was the chief appraiser when the appraisal function was consolidated with the Office of Appraisal Services in OST and the Office of Valuation Services for the federal land side of our operations were combined in 2018. And so I've kind of seen how this has evolved over time. And one of the other things I wanted to point out on here is that I don't come to this from a traditional appraisal perspective. My background's in wildlife management, so I don't look at things maybe as much from an economic standpoint or a marketing or finance perspective. I look at it, I have a little bit different take on things. So most appraisers are not wildlife biologists. They're banking, finance, those types of things. But what I would also say on that is economically, that is one of the key things in this whole process is economics and incentives and which party's acting which way for what reasons. And those are the key things I think that I've seen over my career in negotiation, whether it was for rights of way on Indian lands or permits to build a cell tower on BLM land or whatever the situation was. There's sometimes flexibilities, and we'll talk a little bit about that. But anyway, that's me. So just remember the guy with the short hair and sunglasses. Remember. So what I wanted to cover today, since AVSO really is, I still think, fairly new. We were created in 2018, and had 2 years of a pandemic to deal with, and so we're just kind of getting back into a really high production mode. So I want to give you a quick overview of AVSO, who we are, what we do. Go a quick refresher on 25 CFR 169. You all may be much more experts than I am on that, but I'll tell you from my perspective what I saw coming in as chief appraiser during the consolidation and looking back at 2015 implementation of 25 CFR 169 and what didn't happen when that regulation was implemented from an appraisal perspective, which gets into the valuation and negotiation piece of it. One thing I really want to kind of focus on too is when we have a negotiation for a right-of-way or any other use really, each side comes to the table with a different perspective and different goals and objectives. And so whether you're the party granting the right-of-way on your land or the party trying to acquire a right-of-way for your particular uses, you have a different approach. You have different goals and objectives in the negotiation that may not be understood well by the other side. And so we'll talk a little bit about that. The bulk of this, I have a lot of information here about questions to ask and what's critical to know or to establish as part of that negotiation. Because there are a few things that you might only get one shot at, and you want to make sure that they're addressed when it's being negotiated. The checklist is kind of just a thing not to forget when you're starting to negotiate, and then So I have to give the official disclaimer before we start. I'm not an attorney. I may talk a lot about the regulations and different interpretations of those regulations, but I'm not an attorney. And I am here in an official capacity as the director of the Appraisal Valuation Services Office. Some of the things I say may not be department positions. So this is kind of my perspective, my experience in looking at these things from where I sit. And then, if you do have questions of a legal nature, I would encourage you to talk to an attorney that knows about rights of way before you make any big decisions like that. But my intent today is to give you information to help you ask more relevant, pertinent questions as part of the negotiation process, and to make sure that Indian landowners or tribes are being treated fairly by these companies that are seeking rights of way across your lands, because I don't think that's always been the case, at least from my perspective. Okay, so this kind of is just a brief summary of what we're going to talk about today. And the one thing, if nothing else, I want you to take away from this is that if the impact to the property is high, then the compensation should be higher. If it damages the property, if it diminishes the use of the property, if it causes you to have to change farming or grazing, plans or management plans, any of those types of things that cause the landowner to be, we'll just say, harmed, for lack of a better term, those are the things you should be compensated for. And so, just as a very general rule, if the impact of the right-of-way is more significant, then the compensation should reflect that. And that's a key piece of kind of where I think you'll see us go today. So one of the other nuances here, as you see, is as we go through this, is if there's only a minor impact, there should be minor compensation. That's what people tend to think. So if you have a piece of grazing land at Fort Berthold and the grass is only this big on a good year, that doesn't mean necessarily that you should be entitled to the loss of grazing revenue for that right-of-way when they're putting a transmission pipeline through it that's going to charge other companies to use their pipeline and generate income. So one of the things that 25 CFR did when it was redrafted, republished, was it allows the landowner to really look at what it's worth to the company. How much is it really worth to you to have this right-of-way across my land? And that's something that's not unusual. It's not, it's unique, but it's not necessarily, I guess, totally off the wall, because even the Yellow Book, are you familiar with the Yellow Book? Have you heard about the Yellow Book, the Uniform Appraisal Standards for Federal Land Acquisition? It's kind of the Bible when the federal government acquires property. Even the Yellow Book recognizes when the government grants a right-of-way across federal land, they can look to what's it worth to the person applying. So there's no limitation really on that aspect of it when the government grants these. And if you're granting right-of-way across lands that you're negotiating for, there's no bar on you, trying to figure out, well, what's it worth? What's it worth to this company? So that's kind of where we're going. And the last thing there, eminent domain. I know there's some. There's rules of thumb, I guess, or conventional wisdom out there that if a property can be condemned if it doesn't have any fractional or tribal ownership, and this is where I'll get into the murkiness, and you guys can correct me if I'm wrong. But my understanding is that if a tribe owns any portion of the land, then they can't condemn it. But also, there's been kind of a shift in some court cases, not in Indian country, but in other areas, is that condemnation authority by a private company has kind of come into question. And so, is it really worth it for a company to go through the effort and time to condemn something when what they really care about is getting a right-of-way, say for a pipeline to get oil to market? If it takes them 3 years to condemn something, is it really worth it? What's that piece of it worth to them? So There's a lot of different aspects, and we'll touch on that as well. One thing before we go on, all the pictures that I have up here today are actually taken by our staff at different locations where we work on cases, and so just want to acknowledge that these are our staff pictures, and you'll see they're all over the place. So we have a large footprint, and I'll get into that in just a second. So just a little background on AVSO. So we are the consolidated office for appraisals within the Department of the Interior. 2018 Secretarial Order 363 combined the former Office of Appraisal Services and OST and the Office of Valuation Services in Office of Policy Management Budget into a single office. And so we are located within the Office of Policy Management Budget within the Office of the Secretary. That's where we sit in the organization. One of the big things is going back to 1968, if you can believe that, an independent separate appraisal office was recommended in one of the first audits done, and that even predates the Office of the Inspector General, that they said this needs to be a separate independent function so that it can, stand up to program and political pressures. There's no other department in the federal government that has that kind of arrangement. The closest analog we would have would be USDA, where they have rural housing, Forest Service, there's one other one I'm thinking of, FSA, I think it is. They're all under the USDA umbrella, but they're all separate offices still, they're not combined. So we are sort of unique, and that timeline just kind of shows how this has evolved from the audits in the late 90s and early 2000s to where we are today. We do a lot of work. Sometimes it seems like appraisal is the bottleneck in the whole process. We do accomplish a lot, and I wanted to make sure and highlight that. This is kind of a breakdown. The middle one on the Indian lands it includes all of the land buyback for tribal nations figures that we have done. This was through FY21. So it's interesting to see the differences between the two kind of functional areas, the federal lands and the Indian lands. I think on the average dollar amount per acre on the federal lands is about $2,600 an acre if you just do the rough math, and on the Indian lands it's about $1,100 an acre. I don't know that tells us much, but it is interesting that we have far more cases in Indian country, and the values per acre tend to be higher on the federal land side, and it's just the nature of what the properties that are being acquired by the federal government versus a lot of the work we do in Indian country is not for acquisition, it's for other purposes, and so that also makes that value per acre kind of come down. Our Office of Minerals Evaluation is also very active, and they support probate work in Oklahoma and a lot of other cases. We have geologists, mineral economists, and petroleum engineers on that staff as well. There's about 10 of them, and they help us in doing mineral deeds and things like that. So that's kind of who we are, what we do, and what we did over FY21. I will say this is again, all of these were increases from 2020, but this was during the pandemic when we had shifted everybody to remote work, and so we still were able to stay productive, and we've seen that's a positive going forward as we're looking at recruiting and retaining our staff. Any questions so far? That was all just pretty basic background stuff. So what I wanted to get into next is right-of-way refresher, and again, I'm not gonna, there's been multiple training sessions over the years on 25 CFR 169. I'm not gonna rehash the whole thing here, but I did want to point out some of the areas that I think are the most critical to understand as we talk about negotiating rights of way, because there's some pretty unique things in 25 CFR 169 when you compare it to the right-of-way regulations for like federal lands. So like BLM's is 43 CFR 2800. They do both under FLPMA and the Mineral Leasing Act, but they have very, very different restrictions on how they can issue rights of way. I think 25 CFR 169 in a lot of ways is much better, and it's actually what the IG's office recommended for the federal lands groups when they did an audit in 2014, but it didn't go anywhere with the federal lands side. So, and we'll get into that as well. So the next thing I wanted to bring up the terms. So terms are important. Words mean things. I think you hear that quite often. And there's some unique things in 25 CFR 169. One of the biggest, well, I guess, looking at compensation, what is compensation, and then defines easement and right of way, which is why we're here. And they're kind of not circular, but they're all related. They're intertwined because right of way means an easement. Well, an easement is this, and so you kind of get this idea that these things are all tied together. But the key one to take away from here, and we'll spend a little time digging into it a little deeper, is the fair market value. Fair market value means the amount of compensation that a right of way would most probably command in an open and competitive market. So that is different than any definition of market value you will see in any appraisal text or any other regulation. That is unique to this one. And that has some good and some bad. And we will take a pretty deep dive into that definition here in just a minute. Let's see. Yeah, so that is definitely the one to understand. But another key piece of that is you'll see how compensation is wrapped into the definition of market value, and then it defines compensation. So if you're a fan of algebra from back in your high school days, you can substitute a variable for a certain other equation. Well, in this case, you can actually kind of take out, replace the word compensation with the definition of compensation as you think about this, and that kind of helps frame the fair market value piece of it. And again, it makes a very unique situation, and some of our staff, even when this first happened, said, I don't agree with that. That's not market value. And it's like, well, that's what the regulation says. So if the definition is in the regulation, which has support effect of law, then that's what market value is for this situation. So you like it or not, this is what it is, and we need to figure out how to work with this. You can't just say, I don't like it, so I'm not going to do it. I'm going to follow the old way. We're not going to do it that way. And that has taken a big shift, I will say real quick, is even with the contract appraisers that might be hired by a pipeline company or some other right-of-way applicant, it's been a big shift in mentality for them, because for many years they did it one way and only one way, and this is different. And so it's been a real challenge to try to bring them up to speed as well.
I have a question.
Yeah.
Can you talk a little bit more about the difference, or when you would use an easement versus the right-of-way? I'm seeing in the easement definition too that the title remains vested in the landowner, but it does in the right-of-way too, doesn't it?
So that's a good question, and that's probably more of a legal question, but my interpretation in looking at the two definitions is they're trying to use them interchangeably. And so the title will remain with the landowner on these, because they're not in perpetuity grant. And that's one of the difficulties we'll get into a little bit about talking about what are other rights of way going for, is most of the time they're going to be in perpetuity rather than a 20-year term or a 30-year term, which is what is limited on Indian rights of way. And so they are used kind of interchangeably, where it says a right of way means an easement, and an easement means an interest, but it retains, my understanding is it retains ownership. The landowner retains ownership. It's just more like, almost like a grant or a permit to do whatever they're doing for the term of the right of way. I saw a hand in the back there.
Yeah, that's a common point of confusion. The good way to think about it is a right-of-way is a type of easement. So an easement is a wide category, and a right-of-way is a smaller category of easement.
That's a great point, because if you think about like a conservation easement as an example, that's an easement as well, but it's a totally different mechanism. And in that case, again, the title remains with the landowner. It's just that now they're prohibited from doing certain things on that property by the terms of the easement. So Yeah, that's a great point. It's a broad category, and a right-of-way is a type of an easement. There's lots of other types.
Because we've had situations where we discussed, you know, the county or municipality, one says, let's do an easement, and one says, let's do a right of way, and, you know, kind of going back and forth, and more times than not, we'll end up with the right of way. And does that have something to do too with the BIA, what they need to approve?
It may,
You know, with either one of those types of vehicles or instruments that you use?
I think, and I'm probably stepping out of my appraisal realm a little bit, but I think my understanding is that because the regulations talk about rights of way across Indian lands, that's what BIA would be looking for as a right of way, which is an easement, but is a very limited easement. So it gets kind of, that does get kind of circular in that aspect.
Thank you.
Mm-hmm. Okay, so here's where we want to dig in a little bit more on the definition of fair market value. Again, it has the definition here, but one of the things that this does in effect is basically separates the idea that the value of the land is the absolute maximum that you should pay for a right of way, or you should get for a right of way. And so, I've heard the argument from applicants or say, we'll just say little companies, but that's what I've had the most experience with on these things. Well, why would I pay more for the right of way than what the land's worth? Because I could just buy the land. Well, that's not true, because the land's not for sale, for one thing. The other thing is that the way 25 CFR is written, it allows the landowner to say, okay, well, there's this whole list of other things, which I think I'll get to in the next slide, that we can consider that are negotiable. There's things besides the land value that impact me as a landowner, or my ability to manage my land, or my ability to be productive on my land, or enjoy my land. So there's lots of other things, but this does really kind of draw that line between the value of the land, which is how it's always done in the past, and the right of way. And this was, like I said before, this was recommended in the OIG audit on rights of way across federal lands, and it never went anywhere. So I guess in that aspect, Indian landowners or tribal landowners have a lot more flexibility and ability to really get more of what they should get as far as compensation for these rights of way. So another thing to think about, kind of on that aspect of being divorced from the land, is there's other costs to think about when a right of way, or we'll just say pipeline company, it's just easier for me to do that. If I know there's other types of rights of way out there, but I'll just use that for discussion purposes today. They may, say they've got a pipeline coming, and it comes to your property that you're representing or you're negotiating, and if you say, no, I don't want a right of way, and you're able to do that legally, what's it gonna cost them to reroute that versus paying you, the additional amount you feel is appropriate for compensation? What about, that's like cost avoidance. What about timing? If it costs them additional time and effort to move the right of way or condemn the property, how much is that time worth to them? I know in a lot of discussions I've had with the Federal Partners Group for Fort Berthold, I've attended a lot of those meetings, and the big thing that industry always says is, we have a very short field season in North Dakota. We want to make sure and be able to get in the field, to get these pipelines in, and the right of way is the impediment to us doing that. And so maybe timing is worth a lot of money to them if it can happen sooner. And so, or if there's additional risk for moving it sooner, that you may not have enough time as a landowner to fully vet some of those things, the risk ascribes to you that, okay, well, I went ahead and signed this really quickly, but I didn't really know all the details, and now they're filling in the blanks, and it's like, okay, now this has a different impact on me than I thought. Well, if you're not gonna have the time to do that, maybe the risk is higher, so the compensation needs to be higher. So there are some other things to talk about there. Any specific questions about fair market value, right?
As an appraiser, do you appraise a right of way? And do you put in the appraisal, you know, timing, the cost to move it?
It's a good question.
Do you
So,
validate that in appraisal?
well, so not always. So it's a really good question, and I can't remember if I have a slide on it later or not, but I think let me just look real quick, because I think I do. It's a ways down there, so I'll touch on it now. No, that's okay. And so in the past, when a right-of-way company would come in and say it's, you know, some big oil company at Fort Berthold, they say we want a right-of-way across this. We hired this appraiser. He went out, and the way he would look at it, he'd say, here's the value of the land before the pipeline goes in. Here's the value of the land with the pipeline in. And typically, and then the difference is what is represented as the value of the right-of-way. Now, you're not really valuing the right-of-way. You're valuing the before land value and the after land value, and then the difference that falls out is what the right-of-way compensation amount was. This is in the past. This is not how it's done now, but this is how they did it before. The other technique that you might hear of or that they use is called across the fence. And across the fence means they just look at land across the fence and say, what is that land worth? The right-of-way takes up this many acres. I'm going to multiply it times the acreage per acre value of land across the fence, and so that's what your damages are, is whatever that land value is. So they were very much tied to the land value, but the right-of-way itself was never valued. It was always a product of two valuations or the valuation of the land across the fence, and that being transferred to the right-of-way. That's another thing that 25 CFR changed, because now we're actually valuing or determining the compensation, the market value of the right-of-way based on what other rights of way are going for. So that is a big shift in methodology. Yeah, and so, you know, the key thing too on that is that it's, you know, in the market, say, so what an appraiser's job always is to reflect the market under the terms or the authorities that were being given. And so in this case, if the market is still responding by, say, a private landowner, non-Indian private landowner is negotiating with a power company, they may still come to that person and say, we did the before, we did the after, here's the land value, and here's what we're going to offer you. If that's what's driving the market in that local area, that's still going to be what this reflects even under the new one, because we're looking at the rights of way themselves as comparables rather than this land sold for this land sold for this. Now we're saying this right of way, the compensation was this, it had all of these things negotiated into it, then how do we translate that to this particular right of way across Indian lands and come up with an amount of compensation that is fair, just under the regulation. So it was a complete, you know, shift in mentality. But now we're valuing the rights of way versus valuing the lands.
So when you're valuing with other rights of ways comps, you would do it with like service, correct?
Try to, yeah, absolutely.
I mean, because we have gas, we have electrical, I would not compare the two, just
Right.
so people.
Yeah, and that's a good point, because, you know, I always look at it from an appraisal standpoint. When you throw a pebble in a pond, the ripples kind of, you know, go outward. And I always want, or a target even, you look at a bullseye and you say, okay, I always want my comps to be as tight to the bullseye as possible, but realizing, especially in something like this, where some of this information, this data is very closely held, it becomes really difficult to find enough that are in that first circle. So now I'm going to go out to the second circle. That might be geography, it might be use type, it might be, you know, some other characteristic of the right-of-way, but I've got to get to a point where I feel like I have enough that I can make a defensible conclusion of what that final number is. So it changes and it varies, and some of it depends on the data that's available, but some of it depends on the use. And so you might, like, just as an example, at Fort Berthold, I did a pretty deep dive on what the state of North Dakota does on their rights of way. And looking at a lot of different data points that I got from the state, there really was no appreciable difference between, say, a gas gathering pipeline and an oil gathering pipeline. But there was a big difference between a gathering pipeline and a transmission pipeline. So that, you know, there's those kinds of things where it might be that gas gathering and oil gathering are similar enough that you could use to make a good comparison. But, you know, an overhead electric line may not be the same as an underground fiber optic line, might not be the same as a pipeline. So there are those nuances. There's a question back here.
So if, for a right of way, if your office sent someone out and the company sent an MAI appraiser out, are you saying that your standards have more flexibility than, for instance, an MAI appraiser?
So the MAI appraiser, hired by the private company, this is where we'll get into talking about the parties and their motivations, and kind of they have the same flexibility as we do. And they should follow the regulations just like we do, so that we're comparing apples to apples. What frequently happens is they'll throw out, I'm glad you brought the whole MAI thing up, but you know, they'll hire this, you know, hired gun basically to do what they want to do and say, well, and I'll just tell you what I've seen, and again, this is not necessarily department perspective, but this is what I've seen. So, oil company goes out, hires an appraiser, does the appraisal as the oil company tells them to do. They do it before and after on grazing land. They come back and they say, yeah, well, you know, we did the before and after, and we think it's worth $700 an acre, and so we're going to multiply that times the acreage in the right of way, and that's, we're going to, you know, the compensation is only, say it was 10 acres, let's make the math easy for my slow brain. You know, it's going to make that about 10 acres, $700, going to make $7,000. But we don't think that's right, so we're going to give you, you know, $35,000. We'll give you 5 times what the market value is by our appraisal standards, and you know, here's a check for $35,000. You know, take it or leave it. Well, that sounds like they're being overly generous and, you know, willing to give you a lot of money for the right of way. And compared to what they did, yeah, they probably are. But the reality is, if you look at, like, say, the state of North Dakota, for example, most of their rights of way are done on a per rod basis, and they're getting $300 to $500 per rod, which is 16 feet long. So you take 16 feet times, that's what the rod is, 16 feet long. So if you figure out how long the right of way is, take it times 16, take it times 300, sometimes they're paying a third of what the market shows for rights of way. But they're being somewhat disingenuous by saying, I'll give you 5 times the market value. Well, it's not this market value. It's not the 25 CFR market value they're doing. They're doing some other past version of market value that's not in the current regulations. And so, whether it's an MAI or not, we have a lot of MAIs on our staff. I think last count we had 32 MAIs on our staff. And so, you know, they can throw MAI out there all they want, and that's fine, we have them too. So, you know, my point is, though, they should be following the regulations, what the regulations say, regardless of the credentials of their appraiser or how knowledgeable they are of the market. If they're not doing the appraisal to standard, to the regulation requirement, it's not really usable for the purposes that we need it for.
So you mentioned earlier that we also could take into account evaluation, what the grantee's use is going to be. Are they going to generate income off of getting that right away and so forth? So when you're talking about things like, you know, pipeline today, or whatever it might be, does that economic impact that they will start generating something from? Is that different in an appraisal, or is there guidelines now in 25 that'll make you factor in that economic value that grantee gains from that right away?
So and we'll get into that in just a second, but no, that's fine. And I'll start with this, is that what 25 CFR did was it put in this whole laundry list, and we'll get to that in just a second, of things that can be included in the compensation amount. So previously, if we were looking at a right-of-way and we said, oh, well, these are non-realty items that are included in the compensation, so we kind of have to ignore those. And we're just trying to get the land value. In this case now, 25 CFR 169, I think it's section 112, says, here's a list of things that can be considered. And so if we're seeing in the market that everybody's negotiating a per barrel rate for the amount of oil that flows through the pipeline across your right-of-way, then that's what the market is for that right-of-way according to 25 CFR. We no longer have to take that out. We can use that as part of the market evidence to support the valuation of the right-of-way. So that was a big shift. It didn't say you have to add it in or we're going to identify every of it. It just said that if it's in the compensation amount that's negotiated, you don't have to discount that because that's allowable as part of the market value determination.
I imagine that's where a lot of discrepancy between, the company's appraisal and another appraisal might be, because that's gonna be a lot more, uncertain.
Right. And how do you measure that?
Yeah,
So
exactly.
unless you have a gauging station at one edge of your property and a gauging station at the other end, you're probably not. Or if you can extrapolate it from, a valve somewhere else that has a meter on it to over here and say, well, we think this many barrels of oil passed through during this time frame, and so I want a nickel a barrel or something like that. That's a challenge, and I think that's why it's not negotiated a whole lot. But it's something that can be, and it's something that's in there. And we'll get into that in the next slide, I think. Let's see here. Yeah. So here's the list that basically is in 112. When you look at this, these are all the things that can be included in the negotiation. So some of these you're probably familiar with, some of them you might not be as well known, but like throughput. Okay, what is throughput? Throughput is whatever's flowing through the right-of-way. So if it's oil, if it's power, if it's water, if it's data through a fiber optic cable, those are all the types of things that flow through the right-of-way. And throughput basically refers to what is moving through there. It could be, trains for a railroad track. It could be cars on the road. It could be whatever that right-of-way allows to pass through the property. That's what throughput is. Severance damages is really kind of what we were talking about before with the land value. It's like the value. It's the more traditional way of looking at the value of a right-of-way. What are the damages to the remainder? What harm has been done to the landowner by the imposition of this easement? And really the design of the severance damages was to offset damages to the remainder and make the landowner whole as payment for the right-of-way. Franchise fees is an interesting one. I did a lot of research on municipalities sometimes will charge a franchise fee to, say, a company that wants to install a right-of-way on lands managed by that municipality. Sometimes it's a one-time fee, sometimes it's a recurring fee. The easiest way I can think to explain it is like a royalty fee. It's in addition to rent. It's more of like like if you were, say you had a McDonald's on a corner pad at a shopping center, and part of your rent was 5% of your gross sales paid every month to the landlord. This is kind of the same type of thing. You're taking this is like an additional cut besides what the compensation is for the right-of-way, but it's in that overall compensation package. I don't see those a lot. Some of the bigger cities do use that. If say you want to put a right-of-way in an existing right-of-way that's owned by the city, they may charge you a franchise fee to do that. There's not really any damages to the remainder because the right-of-way already exists and might already have multiple pipelines or power lines or other things in it. They're just charging you an additional fee for the use of the right-of-way. So it's kind of similar to a royalty fee that you get as a landowner without really taking much more into account. Avoidance fees or avoidance value, I touched on that a little bit earlier, where if the pipeline company has to reroute, it's worth quite a bit of money to them not to have to reroute. And so, the compensation amount may go up to a limit where there's a break-even point for the company and says, okay, well, I can reroute for this cost, so I'm not going to pay that much. But but I'll pay, you know, up to 80% of my avoidance cost because that way I don't have to reroute it and still go through there. Again, that's gonna be something beyond what's typical for land values. And then there's bonuses, and then they left this open-ended, other factors. Well, what are other factors? Could be a lot of different things. I guess one of the key things that I always think about in negotiation, if you don't ask for it, you're never gonna get it. It's kind of like, I'm never gonna win the lottery if I don't buy a ticket. Well, if I don't ask for avoidance fees or something like that in my negotiation, what's the worst thing to do? Say no. But if you don't ask, you're never gonna get it. So those are kind of some of those things. And there's other factors. I've heard stories about, you know, sometimes in fact, IG cited a couple of them where some rights of way on tribal lands, the negotiated amount was very, very high. And if you start looking into those, or you're able to find out any information, sometimes there are a lot of things in there that were negotiated as part of the compensation amount that are totally unrelated to the right of way itself, but it was like, okay, well, if you want this, this is what we want. And they're not related at all to any of the things directly associated with the right of way. So if I think that other factors term in there left that open to, you know, we want an endowment for a library, or, you know, I've seen some kind of crazy things. Question in the back.
Is when you take into consideration the throughput fees, are you taking it as a present value of what's going to happen over the life of the easement, of the right of way, or are you saying, well, it's an annual payment of X to recognize the throughput?
And I think you could do both. You could do or either or. I mean, you could say, it depends what works best for you as the landowner. Is it better for me to get an upfront lump sum payment, or is it better for me to get annual income that's predictable?
But you as the appraiser, are you giving the landowner A and B then? Are you saying present value of 20 years of this pipeline is X, or in the alternative, it's 20 times each year it's 1/20 or something?
So yeah, so the answer, I guess the best answer I can give you is to say if it was an annual payment, it would be the net present value of that annual payment would be what we would be looking at. If it was a lump sum payment, we would just use the lump sum payment. But we would have to discount the future payments back to a present value. You're correct.
So it's at the point in time of your appraisal, you're projecting out to find present value, but you're not saying, okay, you have to pay X dollars each year for 20 years.
Right.
Unless the party negotiates.
Right, yeah, if it makes sense for you from an economic standpoint to get an annual payment, that's something that can be negotiated. But if the market is all doing lump sum payments, then that's probably what we're gonna say the market looks at. But that doesn't mean you can't negotiate that. It's just that the value, to compare apples to apples, that future income has to be discounted back to a present value. Because every appraisal is a snapshot in time, and that's why the data value is so critical in these things, is because that's when we set that opinion, is based on that. And so if it's 20 years of income, and that'd be no different if you had an apartment and a 20-year lease, and you want to know what it's worth today if I'm going to sell it to somebody else. You know, the right to receive that income is what you're really valuing. It's not the income itself. It's like, okay, I got guaranteed income pretty much for 20 years. That's worth something today, but it's probably less than the total amount of the income I would receive over 20 years.
This might be a dumb question.
No.
But I just want to clarify the role of your office, the scheme of things, is you're using these new definitions, which seem better, to provide a floor to protect the landowner that you're not gonna receive a payment less than that, but the ceiling is what we negotiate.
Right, so really the role of our office is, and this will sound funny, but it's to determine if the compensation is just on behalf of the secretary. And so basically, we are kind of establishing, this is what the market says you should get for this right of way. And anything you negotiate above that, that's great. I mean, but we're saying as long as it's this amount, it's okay with the secretary.
But from a tribal perspective, we could work with your office to maybe spitball some of those things other tribes have done for negotiation.
If we have that data,
Yeah.
a lot of it we don't, and that's one of the weakest things in all of this. The new regs sound great. Guess what? Oil companies don't want to share with you what they're paying the neighbor for their right of way. Power companies don't want to. Renewable energy companies are even worse. So yeah, we can help with that for sure in whatever way we can. We have market data, and like some places like Fort Berthold, I hate to keep going back there, but that's where the bulk of my experience lately has been, is that they've been keeping track of negotiated compensation amounts, and so we kind of had a database that we were able to draw from, and then looking at the state of North Dakota, who's been very open, their books are open. You send in a request for how much they're paying for rights of way, and they'll send you volumes of stuff, and that's on all different types of pipelines and rights of way. And so by gathering a lot of that stuff, sometimes like at Fort Berthold, we were even able to develop a schedule and say, okay, you know, here's the amount that we think is just. We didn't even have to do appraisals up there anymore on a lot of right of ways. If it's above this amount, if you negotiate above this amount, we're good to go. We don't even have to do an appraisal. And so as the data becomes more mature, we're able to do better analyses and provide better detailed kind of land value schedules and those sorts of things to help keep the process moving. But yeah, you're right. I mean, our role is really to say, you get at least this as market value. If you get above that, good for you. That's kind of where it is. And we can do whatever we can to help you. I'm not saying we may not have enough data to do anything meaningful at this point, or you know, there may even need to be a contract appraisal done that gathers some of that data, and then we basically through the contract purchase that data so that we have it to start looking at and generating our own valuation tools to use.
But it sounds like there's an opportunity for collaboration between the
Yes.
tribes and your office to kind of build that data set.
Right, absolutely. We'd love to help out, because really the weak link in all of this is data. And the more data we can gather, the more finally we can tune the process and start to identify. And again, this is, even though this was 2015, this is still a new and somewhat radical thinking about rights of way. It's not the traditional way. It's not the way it's been done for many, many years. And part of that was to give Indian landowners equal footing, or even maybe better than equal footing, when they negotiate these things. So you can't go here.
Oh yeah, what are you guys doing like about past usage fees? Because I know on our reservation, one of my jobs that I do is we go to companies that have existing right-of-ways that have been in usage for like 40, 50 years sometimes, and we charge them past usage fees for like surface damage compensation. And some of them we end up getting a lot of money back for. I mean, I think that's something that a lot of these tribes should look into, because a lot of them have been taken advantage of for 50, 60, 100 years.
Right. Yeah, we rarely get involved. I won't say we never do, but because I've seen a couple of them where they've asked for like trespass damages going back a certain time, or severance damages going back to a certain period of time. And it's a lot easier for us as appraisers to look backwards, because then we have data to see how we can bring that forward. The crystal ball that we have when we're asked to look at the future is not so clear, but usually in the back, if that's something that we were requested to do, we could do that. We just don't do it a lot unless it's related to a specific case, and sometimes a specific right of way that has been determined for whatever reason by BAA to be wrong or not done correctly back then. So I think the other thing I guess I would say is, going back, we could probably go back to when the regulations changed in 2015, because the rules changed dramatically at that point. So comparing a pre-15 right-of-way compensation amount to what post-15 compensation amount might not be a good way to comparison. So 2015 forward, yeah, I think that's something that we could probably look at. It would come, you know, most of our work is done through BIA. So the requests come to us from BIA. We don't have, other than our 638 programs, we don't have a lot of direct interaction with tribal programs, but that doesn't mean that it couldn't happen. So, and we could figure out how to make that work, I think, probably. But we could look at that.
So you probably have to write that, drop that into your ROW agreement then, if you wanted to do that or look at it periodically. And then it seems to me then, if you are gonna value severance damages when you grant that that right away, you should be clear about what that entails and what that covers. If you're gonna look in the future to have additional, like he had mentioned, surface damage compensation or trespass compensation, if it's gonna be ongoing, I think then we would have to do that, right? I mean, is there another way to, because they're probably not gonna come back and allow you to do it later, right?
Yeah, that's one of the key things, and it's, renewal is actually one of the pieces of negotiation that needs to happen. So how do we do this? You know, you want this, I think it's okay, how are we gonna do the renewal when it comes up? Is it automatic? Is it, you know, we're gonna revisit some of this stuff at the time of renewal? What does that look like as part of the negotiation process? I just looked at my watch and I gotta keep moving a little bit here. But those are all great questions and I appreciate it very much. It's a lot easier to do that than just listen to me read, look at the slide. So one of the key things I think for your interest and information is if you can get your hands on the final rule that was published for 25 CFR 169, which is the one that goes through all the comments that were received and addresses all the comments and talks about the reasons why the rule was written the way the rule was written. Get your hands on a copy of that. It's on the Federal Register. You can find it, and if not, you can send me an email and I'll get you a copy of it. But you know, this I pulled these quotes out of that final rule, and these are kind of important because one of the complaints that industry made was, well, this is just going to cause rights of way to go through the roof. You know, if there's no cap on what can be negotiated, then how are we going to know what to expect? And you know, that it will increase. The other thing was it will increase the use of eminent domain. Well, only to a point. They know what their costs are to condemn. It's not cheap and it's not quick. So there is that area in between that is ripe for negotiation, I think. And another thing, that last paragraph, so if we go back to the list that has all these things in there, when this first rolled out, there was some thought that these were all like additives. So we'll do the value of the land in the right of way, and then we'll add on this piece, and then we'll add on this piece, and then we'll add on this piece. And that was never the intent. In talking with the solicitor's office that wrote the rule, their intent was, as I described before, is that if these are included in other right of way negotiations, they can stay in there. They just, you know, it's not intended that it would be this plus this plus this plus this. And one of the things that kind of hung this up early on was that the interpretation that this was additive, people saw this list and said, okay, well, I need to do the land value in the appraisal, and now I need to do the throughput value, and now I need to do this value. And that wasn't the case, because throughput might not be something in your market that's done. Or cost avoidance, you might not know until you say no, until they can come back and say, well, okay, I can negotiate up to here because it's still economic for me to work through that. So get your hands on a copy of that, and if you can't find it, send me a note and I'll find it. Let's see, we already talked about fair market value. One thing I wanted to point out here, and we had quite a bit of discussion on this, so how is this different from typical definitions, and how is it the same? So this is the standard pre-15, this is the definition of fair market value that was used for right-of-way appraisals. Why it was used, I'm not clear, because it doesn't make any sense to me that this is what was used for rights-of-way. And the Uniform Appraisal Standards for Federal Land Acquisition is designed for a specific purpose, and it's in the title, land acquisition. So we're not acquiring land, but this is the definition that was used pre-15, and actually, it was used 15 to 18, basically, until the consolidation happened, and we said that's not right. We're gonna rescind that guidance memo, and you're gonna follow 25 CFR 169. So this is pretty lengthy. There's one key phrase in here that shows up in the 25 CFR 169 one as well, open and competitive market. You'll see that again. Most of this other stuff, especially like reasonable exposure time, I'm not going out putting a sign in my right of way saying, hey, I got a right of way for sale, because if there's nobody that needs that right of way, it doesn't do any good. So we don't necessarily have that exposure time. This is just not applicable to rights of way the way we do it now, or the regulations call it. So here's kind of the side-by-side comparison. One, you can see the definition in the yellow book is much longer, and it doesn't talk at all about compensation. It talks about, the value of the land, basically, and how much would it have sold for with all these other factors figured in. So to me, the biggest difference is that we're, again, divorcing the value of the land from the value of the right-of-way. And to your point, we're valuing now the right-of-way based on what other rights-of-way are going for versus the value of the land before and after the right-of-way, or the value of land across the fence. Okay. Any questions while I catch up on my paper? Okay, so like I mentioned before, there's two parties to these transactions. They both have different motivations. They both have different incentives. So for the party acquiring, say we'll just use the pipeline company again, they want to acquire a right of way. This is basically how they do it. We talked about this as well. The before value, the after value, the difference is the amount of compensation. Now, if this goes to condemnation, this is the methodology that's accepted by the court for determining just compensation in a condemnation suit. So that's something to kind of keep in the back of your mind, that if condemnation is possible and likely, your negotiation may have to tailor itself to understand that if this goes to condemnation, we're kind of going back to the pre-2015 methodology for determining the amount of value for the right of way. That doesn't mean that the court's not going to say, well, here's what the regs say, here's what it was pre-15, we're going to split the baby and have it somewhere in the middle. You never know what the court's going to do. But if this is used in condemnation, you're going to get kicked back into that before and after type approach, because that's what the courts know, that's what they've always used, and that's probably what you're likely to get faced with. So the acquiring party, they know what they need for their purposes. They know what they want to acquire. And as we touched on before, it doesn't value the rights that are being acquired, it values the land and the damages to the remainder. Now, if you're conveying the right of way, if you're the landowner and a company comes to you and says, hey, we want a right of way across your land, the first two bullets are what I just said, but if you look at like the state of North Dakota or any state that has school trust lands that grants rights of way across those trust lands, generally their mandate is to acquire the highest return they can for that use of those state lands. And so that's really no different than what the intent was in 25 CFR, at least from what I've been told, was to allow Indian landowners to have that same opportunity to get the maximum amount of return possible for granting of that right of way across Indian lands. And even the yellow book, we just saw the definition of the yellow book, and the title says for federal land acquisitions. Even if the federal government is conveying a right of way across federal lands, they're free to look at the value to the acquirer. So if the oil company really, really needs this to complete their pipeline or to shorten their route or anything like that, if it was across federal lands, we could definitely say, yeah, it's what's it worth to you? Because we're not, it's not like when we're acquiring a right of way, the rules are different because just compensation is defined in the Fifth Amendment to the Constitution, and that we have to follow certain rules when we're acquiring a right-of-way. When we're acquiring private property for public use, it kicks in that constitutional protection. When we're conveying federal property for a different use, that's not the case. So we can look at what it's worth to the party that's requesting it. And even the Yellow Book allows for you to look at going rates. What are the going rates for rights-of-way in that area? And that's what we've been talking about basically, is what is the going rate for a similar type right-of-way in this market area. So it's not, while it's unique in the regulation, it's not unheard of in other aspects. So the 25 CFR 169 ties back to 25 USC 325, and in doing that, it mentions that the BIA does not have the legal authority to limit the amount of that Indian landowners charge for right of way. They may try, they may, they'll do what they're going to do, but they don't have that legal authority to do that. And I like this last part. This is kind of what really got me interested in this when I kind of found out what was going on. Is like, it doesn't establish a ceiling. So, you'll hear that, as I mentioned before, the argument, well, I just buy the land. It's cheaper for me to buy the land than it is to get a right of way if you're going to charge that much. Well, there's reasons why that's not true, but it should not restrict the Indian landowner to any kind of cap on what they can negotiate for that right of way. And our role, getting back to the question earlier, is to just determine that that compensation is just based on the regulations. And there's probably a point where we could say if it goes below this, it's probably not just. But anything here or above, you're good to go. All right, so let's see here. We have 20 minutes left, and so I'll kind of go through these fairly quickly, but if you think of other things on any of these slides that come up about questions that are missing related to what you should ask or things to think about when they come to you and say, I want a right of way across your land. There's a lot in these next few slides, and I tried to just kind of brainstorm all the different things that I could think of or that I found in the research that I did, trying to make sure, okay, what questions as a landowner do I need to ask the company that wants to get this right of way across my property? So first thing you need to know, well, what type of easement is it? What are you going to do? Is it we talked a little bit about, somebody brought up about easements versus rights of way. Well, easement, and I think to your point in the back there, it's a broad term, but so like there's an easement in gross, which is typically a party or party. So like a conservation easement is an easement in gross. It doesn't, it's not something that provides, it runs with the land. It may prohibit a person from doing certain things on the property, and it's held by another party. So we need to know what type of right of way it is, what type of easement that right of way reflects. An appurtenant easement, it's good to know about because that runs with the land. And so if you grant a right of way across your land to your neighbor, and your neighbor sells, an appurtenant easement goes with your neighbor's property if he sells it. So you can't shut off the easement to a new buyer because that runs with the land that it's tied to. So that's, if there's anything in there about the oil company or the pipeline company wants an easement across your property that's going to run with the right of way or something along those lines, that's kind of a flag to look at. It's like, okay, well now I'm committing to something that may, bind a future owner of this property or something like that. So just one of those things to be aware of. Is this subsurface? Is it a pipeline, fiber optic, something like that? Is it above ground? Is it a, what are the impacts to my property depending on the situation, whether it's subsurface or surface? What are we going to do with it? Sometimes I've seen very generic easements and they don't even specify that this is for a pipeline or a power line or whatever. It's like, I just want an easement through your property and we're going to figure out what we need to do with it after that. So ask, what are you going to do with this? Why do you need it? What are you going to put through there, and what substances are permitted in it. I mean, sometimes a subsurface pipeline can be used for multiple different products depending on the situation. Gas may be more risky than oil. Water may be less risky than either one. So it's like, what are you going to do with this, and what is permitted? And it needs to be specific. And this last one probably doesn't apply so much to rights of way on Indian lands, but exclusive versus non-exclusive. Is this something that they can then allow others to use their right of way, kind of piggyback on that right of way, or not? I know in 25 CFR it kind of puts some sideboards on that, but it's something that you need to, that's one of those questions you need to ask. Exclusive, non-exclusive. And these are important because every one of these will kind of dictate the market that we're looking at, to get to the point made earlier about, is it looking at similar type pipeline, or similar type rights of way outside. We need to know all this information so that we can make a meaningful comparison to other rights of way when we're trying to determine compensation. And this is one that I hadn't thought a whole lot about until I started doing some more research on this. Is they need to tell you specifically on your property where that pipeline is going to be, what the boundaries of that right of way are, and it needs to be accurate. They can't just say, well, we want to get a right of way for a pipeline across your property, and it's going to be in this corner, say the southeast corner of your property. That's not good enough, because there might be certain things in the southeast corner that could impact your ability to use the whole property for some purpose. Say it cuts off your access to your road, or say it damages your most fertile area of crop production, or something along those lines. That needs to be very spelled out, and they should not have kind of a carte blanche to put it wherever they want to put it. That should all be something that's nailed down very tightly, and say, okay, here's the boundaries, here's what you're authorized to do, and it should be as detailed as possible. Not every entity is going to be able to get a survey beforehand, but the best information you have is the better. For sure.
So this might not be, feel free to say, dealing with this in our time, but when you've got an easement, you're acquiring the property, and then you see that actually said utilities lie outside of the easement that was granted, how, negotiate on that piece, what, any tips or recommendations, because as, we might be acquiring that property, it's a driveway piece, we'll need to, you just kind of, when you have the survey done, you find that, the culvert or something extends beyond the easement, or the power line isn't quite within that.
So I would say my best, answer to that would be, there'd be two things. You could either do it as, when the renewal comes up, if there's a renewal period, that would be negotiated to either shift the boundaries, or add on and get that additional compensation for where it actually is. My suggestion would be is if, so because it's really kind of a cloud on the title. I mean, it's like, okay, we got this, it's really in trespass because it's outside the boundaries. How do we go back and negotiate that? And so, the seller can clean it up, or they can discount the price to account for the fact that you got to deal with this if you buy this. So there's kind of two ways to do it, but the logical time in my mind would be when it comes up for renewal, would be to try and negotiate that at that point and say, okay, we know this is not in the boundaries, we need to get this fixed. But really, the seller should get it fixed before the sale happens.
Yeah, sometimes, the seller, like,
They're not gonna.
farmer,
Yeah.
but, so that's a good point.
Think about it from the perspective that whatever's not cleaned up, you as the buyer have to clean up, and that's not free. So your sale price should be, it's just like a house. If the carpet needs replaced, so I'm not going to give you full price because I'm going to have to replace the carpet. You can replace the carpet, and I might give you more, but if I got to do it, it's going to cost, and so I'm not paying you as much. So I guess on the legal description, just be as specific as you possibly can. Physical, we've touched on some of this, but one of the things especially on farm ground, make sure how deep it's gonna be, that it needs to be below plow depth, they call it, because that way you're not prohibited from farming on top of it. Another question over here.
Yeah, so the land that right is gonna be on, has already gotten grazed, already gotten,
Okay.
is that going to impact how much your right of way is for your utilities?
Say that again.
Okay, so say there's a situation where land is grazed, so I can use this out, right? Okay, so I get that number. Does that number impact my consignment agreement or my right of way for utilities?
It could, it would depend somewhat on, are you, as the seller, going to retain that right to receive that income? If you're gonna continue to get that income from that right of way, the buyer is not going to get it, then that's gonna be a sellable right to receive that income. The seller's not gonna benefit from it, so the value would not reflect that. Does that make sense?
Yes.
Okay. Yeah, if it stays with the landowner and the buyer's gonna be able to receive that income now, you as the seller should be compensated for the loss of that income stream. But if you're gonna keep that income stream, then it would go with you and it wouldn't go to the new owner. Yeah.
Hi, the vast majority of rights of way I deal with waive valuation. They're tribal and there's a benefit to the tribe and utility easements and that sort of thing. How do you, I gather most of your discussion is about individual landowners to some degree. So how do you calculate a perceived or what the acquirer wants to tell you is a value, a benefit to the landowner? And how does that kind of, I mean, in what circumstances would the secretary, in other words, allow just compensation to include the fact that maybe it's zero because that landowner needs electricity or a water main on their property in which they can pull off of? How do you account for benefit?
Right, and that's a little bit of a challenge with the new rules. In the past, it was all kind of cooked in there. It was damages and benefits were all kind of cooked into the before and after approach. And so, yeah, it damaged the property this much, but the benefits to the landowner are this much and they offset, therefore it's zero. In this aspect, it's, I think it would have to tie back to, I'm just kind of thinking out loud here, it would have to kind of tie back to the fact that the amount of compensation that is just under what our role in the process is might be something different, but the actual decision point, I guess you just have to make the case that it was valuable to the landowner to get that. It would have cost X number of dollars to bring in power from some other source and kind of make that argument. And that probably would be done outside of our oversight, because that would be more like the decision of whether to grant the right of way or not. It wouldn't play directly into the valuation. I'm just trying to think.
It could be below your floor is my question.
Yeah,
right?
it could be below.
There are all sorts of calculations you're doing, and the landowner or the tribe that's trying to put in a bigger utility project across a lot of allotments, for example, they may, say, well, the benefit overall is greater. And in the old methodology, it increases the value of the property to have water and utilities, everything directly provided, perhaps, or a road, another piece of road extended or a road paved or whatever. But now you don't have that kind of, you're not looking at land value per se, and so it could go below the floor and yet still be just, and who makes that determination?
Yeah, that's not us. That's a good question, because I kind of once, I mean, it's bad to say, but we're kind of like a black box. They put the information in, we kick something out, and then it goes somewhere else. And I think it would be BIA, it might be the regional director or whoever's delegated at the regional level that would make that decision. But you're exactly right. I mean, there's situations where it's very advantageous to not take any compensation because of the benefit we receive. My father-in-law did that on he happened to own some land that was adjacent to a railroad siding where they were building a pipeline and they needed somewhere to store all of their stuff. And he said, well, that's fine, I'll rent you the property for the period of time you need it, but I want a new road. And so as part of the negotiation, they built him a brand new, nice, wide gravel road into his property, as part of the compensation for the right of way. So now when you see it, the compensation, they paid him X number of dollars per month in rent, but he also got the new road. And so it was advantageous for him to take less rent because he was paying forward. So those are all calculations that have to be done from an economic standpoint, but it's something that's typically outside of what we do.
Because at the end of the day, the BIA approves or doesn't approve.
Right, exactly. Clear?
How long does AVSO take to actual appraise?
It depends. The appraisal answer is always it depends. If it's in an area where we have staff that's available and can get right on it, it's probably 60 to 90 days, probably. If it's somewhere where we have, just as an example, like in eastern Oklahoma, frequently we'll get like 1,000 requests at one time to do ag leases. And if it happened to come in right after those requests came in, it's probably gonna take longer until those kind of get worked through the system to come in. But, we say our goal to get everything done is in 120 days. That's typically if we have to contract it out. Most of the time in Indian country, we do it in-house. It's all done with our staff appraisers. And so I think realistically, you should expect to get something in, I would say 60 to 90 days. That won't always happen. I'll just be upfront and say that. We right now have 60 vacancies in our staff, 60. We are short-staffed and it's taking longer right now to get things done than what we would like. We're got a lot of different initiatives underway to try and build that staff back up now that we have adequate funding to do that. We have money now, we just can't find appraisers. That's the problem, and that's not unique to us. It's every federal agency, it's lenders, and everybody else is having the same issue. There's just not enough appraisers out there. And that's why we've been also exploring different tools like under the right-of-way regulation. It doesn't say you have to have an appraisal. It has appraisal, market analysis, it has all these other things as long as it's approved by the secretary. Well, if we can give you something other than an individual appraisal that will meet your needs and allow you to move forward, we're happy to work with you to do that, and we might be able to eliminate the need for appraisals almost completely. Like if we're hold on rights of way, we've almost eliminated the need for right of way appraisals at Fort Berthold by developing a market structure. So I would say 60 to 90 days, but don't be surprised if sometimes it takes longer.
Our tribe contracts out to a yellow appraiser, so we're not out 6 months to a year, 6 months to a year.
Okay.
We call them up, let them know what we need, and he gives it to us
Okay.
within 2 weeks.
That's great. In 2 weeks, that's really great. Probably because a big part of it, he has all the market data already.
Yes.
And so he's just he can go to his folder or file and pull that stuff out, and it makes it easy. But yeah, that's really good. And that's something that when we contract out, we have to go through the government contracting process and follow the federal acquisition regulation, which in itself is pretty onerous. And so our acquisition process for just hiring a contract appraiser sometimes is 45, 60, 75 days from the time we ask for the contract to be awarded until the contract's actually awarded. And that's not even counting the appraisal fee. So if you can work directly with them, that's probably a better.
When you set up your schedule, let's say in Fort Berthold, since these are rights of way across tribal trust land, is there a factor in there in terms of a discount because the tax is tax-free, or is that just outside of your appraisal?
No, that's a good point, and actually I'll skip ahead here just a little bit while we're finishing up, but and I'll get to that in just a second here because there's a slide on taxes. So insurance and liability, another thing is like if something happens on the right of way, if they start a forest fire, God forbid, something like that, who's responsible for that? You want to make sure that you as the landowner are not on the hook for something that the right of way company does within the right of way. And who who pays for the insurance? That's even another question. So, you might both agree, but then who pays for it? So these are all, again, negotiations. Now to get to taxes, like you said, some of this goes back to, we were talking earlier about how you receive your payment, your compensation. It may have income tax, or implications for you as a landowner. And I've got an interesting Pennsylvania case here. Damages are considered a capital gain. So the company pays you damages for what they did in installing the right of way. You may be on the hook for income taxes based on it being a capital gain. But the taxes, so if it's taxed, and you're liable for it, I mean, that's, again, I guess, getting back to kind of the same discussion we had before, is if you as a landowner are gonna be obligated to pay the taxes, or that's gonna come back to you, then that's something that needs to be included in your compensation, because you shouldn't be out of pocket for agreeing to grant that right of way. And, as an appraiser, I'm gonna look at the other ones and see, that's one of the things in an appraisal that you always have to look at. What's the tax load? What's the tax burden? Is that something that impacts market value, or is it typical for the market? And so it would be in there. It may not be, if everybody's in the same boat, it's probably not gonna have any impact on the value one way or the other. But if it's something unique because of that, then definitely, yeah, that's something that you want to talk about. Okay.
How do you establish a market schedule, and do you have a CFR for the authority that they go in and say?
Yeah, so the first question is, we gather as much data as we can to try and figure out what that's, what that market area is, what are the drivers in that market area, what are people paying for whatever the value is, the right of way, the land, whatever the situation is. And then we try and stratify it as much as we can. So like, sometimes you'll see in a market schedule that like there's a break point, like we'll just say for land for ease of discussion, at 20 acres, it's worth, 20 acres and below, it's worth $5,000 an acre. When it crosses that 20 acre threshold, maybe it's only $3,000 an acre. And as it gets bigger, maybe it's only $1,500 an acre. And so we try and stratify and say anything less than this acreage is this amount, anything, in between these is this amount. And then like for a right of way, maybe it's by rod. If it's, 100 rods long, it's gonna be this amount. If it's more than that, or it might be width. Sometimes the right of way could be 30 feet, it could be 60 feet, it could be 120 feet. The wider the right of way, if we're using those as comparables, then we have enough of them. That's the key. On the schedule, you gotta have data. We'll try to stratify it by maybe length, width, use type, those types of things, and come up with kind of a matrix that says, if it's a gas pipeline, and it's this long, and it's this wide, it should be this much per acre. So that's that piece. It goes back to, I believe in the, I don't think I have that one written down, but it's in the, I think there's a section in the 25 CFR 169, I can't quote the section, but it talks about like, how will the secretary determine compensation? I think is the question that leads in, and it says like through appraisal, market value, resident analysis, there's like 3 different things, or other methodology approved by the secretary. And it's like one sentence and it has a bunch of things in it. I can't give you the chapter and verse off the top of my head, but it's in there. I believe that question starts as, how does the secretary determine compensation? I think I got just a couple left here. We're probably right at time. So again, you want to make sure who's responsible for what when it comes to maintenance. If the trees have to be trimmed, if the grass has to be cut, if anything like that has to be, if there's noxious weeds that have to be mitigated, who's responsible for that? Sometimes when you disturb the ground, next thing you know, you got a bunch of knapweed or something else coming up that needs to be dealt with. Shouldn't be the landowner's responsibility because they didn't do it. And then covenants. These are just things that can be restrictions on either party. Like the landowner can't go in there and tear up a bunch of stuff that's gonna impact the operation of the right of way. Likewise, the right of way can't drive right through a wheat field to get to the right of way and tear up a bunch of crops. So, there's limitations, covenants on each party to make sure that they're protected in their interest. And then, these are just some other factors to consider. I mean, as we go through here, we've kind of touched on some of these, but you have timber, and they cut down your timber, you put in the right of way, and to maintain the right of way, who's entitled to the money, if you could say, it's merchantable timber, who's entitled to that? Water, standing crops, like if it cuts off an irrigation ditch, or if it goes under an irrigation ditch, or something like that. If they come in during growing season and they tear out a bunch of your corn or your wheat or whatever crop it is, how are you compensated for the loss of revenue from that crop loss? Can you no longer get to fishing and hunting access because the right of way prohibits crossing that? Does it tear up your best hunting area? Or sometimes maybe it creates a corridor that wildlife likes to use, power line corridor, maybe it enhances it, but those things are tangential, but or it could be another one where maybe you lease out property for hunting, and the restrictions of the right of way say that you can't grant other people access to this right of way. Well, now you can't send your hunters over there to hunt in that area, so it might be something that damages your position. Can they build a shed? Can they build a ware yard? Is there anything else on the surface that they can do with this property that would impact maybe just your view? Maybe you have to look at all this pipe piled up on top of their right of way and you don't want to look at it. Or if you're gonna look at it, they're gonna pay you for it. Legal fees, dispute resolution, there's all kinds of factors in there. But what I think my hope is that you would at least start to think about the, it sounds very easy to say, we just want to right of way across your property to put this bike there. Well, there's a whole lot that goes into that request. And those are things that will impact your property for a minimum of probably 20 years. And so I think by asking the questions, you also put them sort of on notice that, hey, I have some questions. I'm coming at this from a position of knowledge, not from just, oh, where's the check? The check maybe should be a lot bigger than what you've gotten in the past or what other people have gotten. So, these are discussion points. Negotiation's not always easy, but definitely if you put the companies on notice that you kind of know there's a lot of different aspects to this that are important and that you as a landowner feel like you want answers to before you agree to something, I think it should be discussed, because I think for many years, and even after the 2015 regulation was passed or put into place, any landowner didn't get what they were entitled to get or what they should have gotten. And we're trying to get that fixed now, and it's been a slow process to kind of change thinking about what this says compared to what was done in the past. So I'm happy to answer any questions. Stick around for a little bit if you guys. I know we're at time and there's other sessions today, but go ahead.
One last quick question.
Yeah.
The second to last thing is things to consider. What is the best way for us to communicate that to our appraisers in your office? The lack of hunting is more practice. Some of those things we may actually be able to quantify.
So the best way, I would say, so as an appraiser, what I'm going to look at is the easement or right of way document, and what's in that document is going to drive what I do for the appraisal purposes. So if the document itself has information in there about hunting, that's what's going to drive it. If you would, in the request, if you would say, we're considering this, is there any market evidence that loss of hunting and fishing access provides
What's the shelf life on your appraisals? 12
I'll-
months?
I'll give you the appraiser answer again, it depends.
Okay.
So right now, in a hot market,
Yeah.
it can be as little as 30 days. You know, if a market is moving rapidly, it changes quickly and the shelf life is less. If you're in an area like, I'll pick on Nevada, Winnemucca, Nevada, middle of the desert, property values haven't changed 5% in 20 years, that shelf life may be 2-3 years. And so it really depends on the market that we're looking at and the type of data we have. Rights of way probably aren't as volatile as like land values. So, you know, generally a rule of thumb is a year, but, you know, depending on the market and where you're at, it could be less.
And will you state that in your appraisal? Will you say, you know, this appraisal is valid for X amount or do you have some kind of disclosure statement that says, you know, if we find any changes, we have the,
Yeah,
you know?
so that's a tricky one. Some agencies do establish a validity period. Like Forest Service, I know when I worked over there, they have a validity period, and they would say it was a year. What we run into typically is the bureaus have their own validity period, and they say, if this gets to be more than a year, we're gonna need an appraisal. From our standpoint, the best way to do it is to look in the appraisal and see how they address market conditions. There's usually an analysis of market conditions in the appraisal report, section in the report, and it will be in the table, like the adjustment table. So if they're putting what often called a time adjustment or something, that'll give you an indication. If the time adjustment is 5% a month, your shelf life's going to be pretty small. If it's 0.1% a year, it's probably got a lot longer shelf life. And so that's where the appraiser will address it. As far as making a specific statement, they may not make a specific statement.
Is there a cost for your services? Is that all free, or do you assess, some type of cost for it?
So we work, I mean, typically we work for BIA and we're funded out of the Indian appropriations legislation. So most of the work we do for BIA is funded, and then we also have oversight and responsibility for tribal appraisal programs.
Yeah.
So that's funded as well. So if it falls into that piece, it's probably not going to be a charge for it. If it was outside of either one of those appropriation lines, then there might be a charge for it.
Okay, thank you.
Yep, sure.